Welcome everyone to this webinar. I'm Rafael Carmona from the ICDR. And before we begin, I want to remind you very briefly that you can join as an ICDR Y&I associate. If you look for our website, ICDR Young and International, you will find in our website registration forms in English and in Spanish. And also you'll be able to find all of our previously recorded webinars. We also have a LinkedIn group that you can join, ICDR Young and International, and we'll be posting all of our updates there also. I will also mention that currently we have a call for applications open to join an ICDR Y&I board. The deadline is December 16th. So if you're interested, you can go to our website, read all the requirements to apply, and you can send your application by the deadline. I also want to thank the panelists and Apurva for organizing this panel, as well as our co-sponsors. And with that, Apurva, I give the floor to you so that you can begin with the webinar. Thank you very much.
Thanks so much, Rafa, and welcome everyone to the fourth program in our International Construction Arbitration series. It's great to see, already so many people joining us from all over the world. And this series in particular has been, a tremendous opportunity to learn about and explore a range of topics that often arise in complex construction disputes. And we're delighted to continue that engaging discussion today. In addition to the thanks that Rafael mentioned, I'd also like to give a special thanks to Irina Akulenko of HKA and Zach Torres Fowler of Troutman Pepper, who were both instrumental in conceiving of and planning our program today. So today we'll be talking about basically what can go wrong on major construction and infrastructure projects. These projects are often fraught with risk and uncertainty, and any number of circumstances can put a project or a contracting party into distress. So we have with us three expert practitioners with a wealth of experience managing precisely such situations, both from a disputes perspective and from a risk management perspective. So I'll briefly introduce our three panelists today. Raid Abu-Manneh is based in London. He's a partner and global co-head of the International Arbitration Group at Mayer Brown. He has extensive experience representing and advising clients in the construction and infrastructure sectors. And his work includes not only acting for clients in arbitrations, but also advising clients on risk management during the course of the design and construction of a project. Raid has advised on a substantial number of disputes in the Middle East, particularly in the infrastructure, power, and energy project. Sally Kotb is based in Dubai and is a partner in the UAE dispute resolution and international arbitration practice of Habib Al-Mullah and Partners, which is a member firm of Baker & McKenzie International. Sally's practice focuses on the resolution of both local and international commercial arbitration disputes across a broad spectrum of industry sectors, including construction, real estate, energy, distribution, M&A, and shareholders disputes. In addition to Sally's roles as an advocate and an arbitrator, she also has deep experience providing strategic advice to clients on contractual issues, including litigation risks and avoidance from a civil law perspective. And last but not least, Scott Ramsden is based in Hong Kong and is a principal and country manager at HKA. He has over 30 years of experience as a construction professional and quantity surveyor, and he's been appointed as an independent quantum expert in arbitral proceedings relating to offshore oil and gas projects. Scott has worked both as a contractor and a consultant to provide international firms with wide-ranging strategic advice. His experience in the construction sector is impressively broad and includes ports, mining, oil and gas, infrastructure, airports, buildings, power and industrial projects, and he has considerable experience in the preparation, defense, negotiation, and settlement of contractual claims. So with that introduction, let's get started. And we invite anyone to ask a question to the panelists throughout the course of today's program using the Q&A function at the bottom of your screen. And we'll try to address those questions live to the extent possible, but we'll also leave some time at the end for Q&A. So, Scott, could you set the stage for us? We'd like to know, what are the typical causes of disruptions and disputes when construction projects are underway? And, we're also facing unique global economic and geopolitical challenges today. And so, I'd be interested in your thoughts. To what extent are those factors and events contributing to the pressures and risks that already face projects and contractors?
Thanks, Apurva, and thanks for having me on the panel. If you could pull up, I've got a couple of slides to help me out with this. If you could pull up the first slide for me. So here at HKA, we every year now for the last 5 years do an integrated research program to analyze and report on the causes of claims and disputes and major capital infrastructure projects worldwide. It's slightly unique in that it's based on first-hand investigations by leading consultants working on projects globally. So this year is our 5th report. It's a distillation of the findings from over 1,600 multi-year projects in over 100 countries up until July of this year. So if we go to the next slide, please, Apurva. So this is kind of our general overview, and we're looking at the numbers by area, but the numbers overall. Delays on projects internationally average about 68-69% of the project program. We're looking at an average capex of $1.5 billion and an average cost claimed of almost $100 million per project. So as we can see, these delays, disruptions, they're major events causing major issues in terms of time delays and cost overruns. I mean, these impacts are huge, and we're talking at 35% of the capital expenditure committed by the conclusion of the current report was in dispute. So it's a major issue across the world, and I think we are looking at these figures, we can see that it's not a lot different wherever we go in the world. So if we go to the next slide, please, Apurva. And these are our findings of the top 10 causes of claims and disputes globally. Ranked number 1, change in scope, and that's number 1 across a number of regions. It's, has been for a number of years one of the most common causes of delays, disruptions, additional cost, and ultimately dispute within the construction industry. Apart from change in scope, the remaining items tend to fluctuate in their importance across different regions. We'll look at that in a little minute. But quite notably, I'd say that a lot of these dominant causes of claims and disputes, most notably the change in scope, unforeseen physical conditions, deficiencies in design or workmanship, commonly arise from what we can only say are short-sighted attempts to save time and money at the front end of a project. It's not uncommon that whether it be a contractor or the employer, that they don't necessarily see the benefit in perhaps spending some money up front to save money later, particularly on the contractor side, where spending that money up front is not necessarily going to be recouped with the nature of contracting and tendering as it is. So we go down the list. Obviously, contract interpretation issues, generally a pre-contract kind of issue that comes in. Design information is an important one across the board in many regions. But then we look at some more kind of contract, current duration of contract issues, which is the contract management, incorrect and incomplete designs and poor management of subcontractors and suppliers interfaces. Access to sites is generally a little bit more of an issue in the Middle East and Asia than it is in other places. Physical conditions, very common issue across the world, and workmanship deficiencies, which seems to be increasing, I would say, in recent times. If you could just flick to the next slide, please, Apurva. So these are the main factors at each stage, excluding our change in scope, which is the main factor across the board for all regions. I mean, contract interpretation issues, contract management, design information being issued late, kind of early construction, pre-construction issues, the access to site, obviously during construction, and the unforeseen conditions and the workmanship, probably the most common during construction period. And then even after construction, you're still looking at deficiencies in workmanship, operational performance issues, and failures in installation. So those are the main things that we come up with across the world, really, in terms of what's impacting these disputes. And next slide, please, Apurva. And just a quick kind of comparison here of a few different regions. So I've chosen Asia, Americas, and the Middle East, probably more because they're areas that I've worked in as opposed to anything else. But as we can see, the change in scope is the top bod across the board. But then it all goes quite different. In Asia, access is a big issue. In the Middle East, it's unforeseen conditions. In Americas, it's more design information. And here we see some of the things that maybe are a little bit more related to culturally in the different areas as well, as to how things are managed. I mean, what we see in Asia quite often is that a project will start and the client hasn't actually secured all the land for the project area, and there will be issues in access and the like. I can talk about a project that I did not too long ago myself, where there were issues with the local village not giving up their land that had been agreed, and probably caused 6 months of delay to that portion of the project site. And I think looking on the client side, capabilities and strategies need to be a little bit more intelligent and mature to secure better performance and outcomes. I think what we need to see in terms of the way that construction is going is clients understanding the capacity and capability of the supply chain prior to determining their procurement and delivery models, and then bringing a project to market. And this is obviously going to improve the likes of, the design, the overall tendering process, and that management of the construction process going forwards. Many problems, I would say, including those revolving around design and contract interpretation, management of subcontractors, the contract administration, can really be avoided. And I would say by doubling down on proven best contract management practices. Currently within construction, particularly in Asia, I would say, increasingly we're suffering from supply chain issues. We are in a period where there's not a lot of demand uncertainty in terms of, there are a lot of projects. There is a lot of supply uncertainty in terms of the supply chain. So, contractors need to be looking at hedging their supply chain models and to overcome those risks. Clients need to be looking at the way that they tender, to manage those risks and to try and more equitably share those risks. I would say that contract price fluctuation is also a big issue there. It's something which is becoming more and more apparent, and recently we see that we're getting a lot more inquiries about claims and disputes involving contract price fluctuation. And that's driven by a number of things. Obviously, the war in Ukraine has had a huge impact on gas prices, which impacts not only the supply chain, but then also the construction process in and of itself. Throughout COVID, we had a lot of issues in terms of the mobility of labor. We were fairly lucky in Hong Kong that construction sites never shut down per se, but certainly in a lot of areas they did. And so you've had some slightly different causes of delay coming to the fore in certain areas. And I think the reflection of the changes across the regions is kind of reflective of how different countries managed COVID across different periods. So I'd say, those are the biggest things we're seeing. These are the things that are making the biggest impacts on the projects that we see and we do. But in terms of managing that, I think one thing that, whether you're on the client or the contractor side, that really needs to be focused on is really just doing the simple things well. Effective contract management reduces disputes, it doesn't increase them. And I know certainly in Asia, people can be reticent to submit notices and things, but it's really a process there to actually prevent disputes by bringing issues to the fore early. Keeping correct records, doing all those things that we know that we should do that we don't really do. Those simple things are what are really going to help us get past a lot of these issues that surround our delays, disruptions, and additional cost. So I think that's all from me on that, Apurva.
Great, thanks, Scott. And we have one question from the audience already, and I'll pose that to you. Joe Kelly asks, what's the difference between change in scope, design deficiencies, and incomplete design? Are they not all intertwined? So I think this is breaking down these different factors or different causes of disputes that are listed here. Could you give us an explainer as to the distinction between those different causes?
Yeah, so change in scope, we find, and I'm sure Sally would have seen this a lot in the Middle East. A project starts, the design is out, and halfway through the project, the client comes along and he looks at his project and says, well, actually, I don't want a blue roof anymore. Can I have it clad in solid gold instead? And all of a sudden, you're looking at major changes, which can be quite simple in terms of what they seem to be on the face of things, but can cause, particularly now with the supply chain issues, even bigger issues. Sorry, the next one was the design deficiencies. So that would be more so just to do with not the design being incomplete, but not necessarily suitable for or fit for purpose. So an incorrect design for the purpose of the building or the structure. And the last one, sorry, Apurva, was sorry, you're
incomplete design.
And was incomplete. So therefore, yeah. So it's not uncommon that it will, a designed project may not be completely designed, or there may be portions that are outstanding at the point of tender or at the point of contract. And that also is probably more of an issue, I would think, in the Middle East and Asia than perhaps in some other areas, but not an uncommon one for sure.
Great, thanks very much. So Scott described a number of causes of disruptions and delays and cost impacts that frequently arise during the course of a project. Sally, can we take a step backward and think about when the parties are at the negotiating table drafting a contract? How do project stakeholders allocate the risk of and responsibility for problems that may arise in the future during construction? And what do you think parties and their legal advisors should keep in mind at the contracting stage in anticipation of those potential problems, whether they're foreseeable or unforeseen, that might impact the project down the road?
Sure, Purva. Thank you for this question. And if you can allow me, I'm going to start from where Scott has ended, really, and just to build on the question on change in scope. And as Scott said, it is really a common issue that we see time and time again in the UAE. And it really comes down, as Scott mentioned, to a term that is commonly used as a variation. So what would constitute a variation in the contract? And the issue that we often see is that parties don't really define their contract properly in terms of risk allocation. So if we're starting to discuss like how can parties allocate the risk, I think parties are now more cognizant of the issues that arise out of contract, especially after the pandemic. So they're giving more time in terms of defining terms. And this really comes to a number of clauses. And the first of which is really variation or change in scope. So at the beginning of a contract, there has been always an issue between employers and contractors, especially in fixed term contracts, where we've seen that parties would agree a certain scope for their construction, and then a certain change in design, or for any other reason, the employer decided to change what is required under the contract. We've seen a lot of examples where the contract didn't really define what would constitute a change in scope, and this gave rise to a number of issues down the line once the dispute arises. So one element is to clearly define certain terms under the contract is one way to ensure a proper implementation of it to avoid contractual misconstructions once the dispute arises. Another element as well comes down to notices, and it's again another point that Scott has mentioned. We've seen a lot of cases where parties do not really comply with notice provisions under the contract, so they would just file their claim for variation without complying with the procedure that is set out in the contract, without providing proper particulars or substantiation of their claim to the employer. This again has led to a number of disputes. We've seen cases where parties would say, you know what, I didn't comply with the notice provision, but I do have a legitimate claim and I am entitled to file that claim in arbitration or litigation. That's unfortunately not the case at all in the Middle East. Courts have taken a very strict approach when it comes to submission of variation claims or any other claim really under the contract, where they've said that time bars and notice provisions need to be strictly complied with. So this is another element where we're seeing in terms of contract negotiation, parties appreciating the importance of adhering to notice provisions. The other point that we've also seen in terms of contract negotiations that parties are giving more attention to termination clauses. Unfortunately, we've seen again a lot of issues coming up at the dispute stage just in terms of interpretation, the termination provisions. The common issue that we see is that parties would just say in their contract, on the basis of certain grounds or on the basis of issues that give rise to a material default on either side, on either party would then be entitled to automatic termination. The issue here is that under the majority of GCC law provisions, there's no clear definition as to what constitutes really a material default. So a material default to the contractor can be, for example, a denial of access to site, whereas to the employers might say, no, but this is like a common risk that you should be aware of. So to avoid, again, these types of disputes or contentions or tension, really, in terms of contract interpretation, parties now give more and more attention as to what would constitute a material default under the contract. The other point that we've seen as well is force majeure. So force majeure is really the magic word that we've kept on hearing time and time again after COVID and the pandemic. And from a Middle Eastern perspective, courts have been consistent in terms of explaining and clarifying that COVID-19 does not constitute a force majeure event, and therefore a party is not entitled to evade from liability on the basis of COVID-19. The other element is that we keep on seeing a lot of attention being made on the basis of force majeure, whereas parties do not really pay equal attention to, for example, hardship, which gives them maybe an easier remedy to try and set the equilibrium back in place as a result of any hardship or unforeseen circumstances. So now that parties understand that they're not better off arguing or evading liability on force majeure, they're giving more and more definition to hardship, saying what would constitute hardship and how the parties can mitigate the risk and mitigate their position once a hardship position comes along. We're also seeing, on the other hand, and on this topic as well, change in law provisions. So parties, instead of now, saying or arguing force majeure to escape liability, they would define and provide a detailed definition as to what would constitute change in law. And this, again, is all tied back to COVID-19. So, thankfully, throughout, in the majority of countries, restrictions have been really relaxed, but contractors and developers, employers, they all know that the risk of COVID-19 is imminent and it can come back anytime. So they're taking this into consideration and they're giving proper attention, not really to say we're going to escape liability, but trying to find ways, flexible ways under the contract to make it work in case we face again lockdowns or travel restrictions. The other element that I wanted to very briefly touch upon is also in relation to dispute resolution. So we always know that arbitration is really the midnight clause that parties just, consider at the very, very late in the day. That's not the case anymore, actually. We're seeing more and more awareness of now companies involving us as dispute lawyers right from the beginning of the contract negotiation to ensure that they're making it right and that they're really limiting the risks that they're facing. One issue here that we've seen is that, and maybe this is a tip that we've all learned from, when there is a supply chain where, a developer would have multiple contracts with one contract with the contractor, another contract with a consultant, the difficulty we've seen is that the developer would agree one dispute resolution clause, for example, litigation with the consultant, and then agree arbitration with the contractor. When a dispute arises, it's just very difficult to then realize that, oh my God, where am I going to go? Am I going to go to multiple forums to get my money back? So as a matter of best practice, they now agree one dispute resolution clause for all contracts related to the same project throughout the supply chains. So these are really the main provisions that I've seen recently. Thank you.
Thanks very much, Sally. Raid, Scott, do you have any comments on contractual provisions and protections and risk mitigation methods at the early stage, and what parties should keep in mind?
Well, I think the key to avoid disputes in virtually any jurisdiction is exactly like Sally said, is you set this up right at inception. During the contract negotiation phase, you try to achieve a careful balance between rights and obligations, liabilities. You said it very eloquently earlier, Bova. There is inherent risk because you're building something based on a design. You don't know, you're taking a fair amount of risk. You don't know what the ground conditions are going to be. You don't know what whether all the subcontractors are going to be there. Are they going to go bankrupt? Scott will tell us about that. Is there going to be a world event in terms of supply issues? Is there going to be steel shortage? But you're taking on, saying, in the next 3 or 4 years, I'm going to build this project. And the question is, you're dealing with 3 main elements. You're dealing with time, the time for completion. You're dealing with price, and you're dealing with the scope. And really, the more upfront, as Scott said, work you do in terms of understanding the project and trying to allocate the risks, the more likely you are to avoid disputes. But the reality of it's disputes, in, as Sally said, in construction projects are unavoidable, because you're not buying a car, you know. You just don't know what you're going to get. In a sense, you've got all of these uncertainties, and that means that you will hit disputes. But the key, I think, is to try and deal with that and limit that. For example, you know, things like caps on liabilities, liquidated damages, define carefully, as Sally said, events to do with termination. There's another way of balancing all of these risks, in the sense you look at the applicable law. Applicable law plays a major role in terms of how you deal with risks. For example, if you were to sign a contract in Saudi Arabia, you would have to deal with balancing, you know, the contract rights with Sharia rights. Okay, so you cannot sign something which is uncertain. That would be gharar, for example, under Saudi law, so under Sharia law. So all of these things, you need to take them into account, and it's an incredibly difficult exercise, because you're trying to read the tea leaves in a way to try and come up with a formula. But it's sort of you know, that's an important thing that you need to take, and you know, at the end of the day, it's about the bargaining position and how much risk you're going to take. I don't know, Scott, whether you want to add to that. So.
Yeah, and let me just interject, and Scott, would love to have your thoughts as well, but I'll add, you know, we've gotten two, I think, very pertinent questions from the audience in the meantime that I think relate to these issues of how best to think about risk, you know, at the contracting stage. And Scott, I'd love your thoughts on these as well, but this is also open to everyone. Ricardo asks, would you say that having recourse to contract forms such as FIDIC or NEC help to narrow the contractual issues, or, you know, does it not make a difference? And Haitham asks, you know, he observes that the problem that both you know, owners and contractors repeat the contractual clauses that take them to dispute rather than to avoid dispute. They interpret the contract clauses in the way that transfers the risk to the other party rather than putting in clauses to reduce the risks. And so, are there ways to escape from this this trend or phenomenon? And Scott, I'll turn, you know, back to you. Then
sure. Yeah. I mean, I would say, you know, in theory, the NEC contract should reduce disputes. You know, that was its intent in terms of the way it was written and the way it was put together. In practice, probably not. But that's more to do with the way that the contract is implemented than the contract itself. And what has happened, you know, historically, and obviously the UK has been using it for a long time. Hong Kong, for example, has only recently, you know, in the last few years, brought in NEC for its government contracts. What happens is when people start using NEC, it's a completely different style of contract. They're not used to it, so they add all the clauses back in that make it look more like FIDIC or look more like JCT, because that's what they're used to, and that takes away the effectiveness of the NEC contract. I mean, I think all of these contracts all have their pluses and minuses, but not one of them really is there to lead you down that road of disputes. You know, the processes are in there to actually settle those disputes during the contract period. So I think, you know, the contracts themselves are fine. I think it's really the way that they're managed, and to a certain extent, the personalities on each side of the dispute, which will kind of define how that dispute goes down.
Thanks, Scott. That's really helpful. So one of the risk allocation mechanisms that we see in many jurisdictions in international projects is where owners require contractors to provide a bond. And so for those practitioners who may be joining us who aren't familiar with how bonds work and what role they play in distressed projects, Raid, could you give us an introduction here?
Yeah.
And tell us what parties should be aware of, either when
Yeah.
providing a bond as a contractor or subcontractor, or either as an owner or main contractor taking the advantage of a bond or even liquidating a bond.
Yeah, I think bonds are phenomenally important because they provide but essentially performance security. And you've got two types of bonds. You've got on demand, you've got default bonds. It's again, it's part of the package that you take into account in terms of balancing risks throughout the execution of the works. The bond provides you certain security in the sense that you are able to call it in certain events. Now, on demand, Sally will tell you some entertaining stories, no doubt, well, maybe not for contractors, about calling bonds in the Middle East and how that's on occasions it's abused by owners for purposes but these are the common instruments that are used and are often sort of used to sort of put pressure on the contractor to do certain things, and we've seen that repeatedly. You know, we will call the bond unless you do this, etc. So that's default bonds are, you know, different, very different animals. They're based on circumstances. It could be like a particular event, an award. It could be insolvency, for example. That could be a trigger for calling, etc. A bond. But what is important, and again, it's not so much with the instruments, but it is the implementation and how parties conduct themselves in terms of these instruments and how they're used. And there is a difference between an on-demand bond and the English courts, for example. The exception to calling a bond is essentially you go to a bank, you're looking at fraud basically being, you know, an exception to allow. I think it's might be different in the Dubai courts as far as I've seen so far. But what is really important is that you know, parties should balance out what these instruments are for. They're not there to provide cash flow. Essentially, when you've got an arbitration, the tribunal tends to take a very considered approach. Now, in arbitration, you often see interim measures right in the beginning. You start the project. You're worried about the calling of the security because, say, you've got the usual mix, a big dispute, big construction dispute. You've got termination, and then of course termination could lead to calling of the bonds. The tribunals, you've got the three tests for interim measures. Irreparable harm, well, it calls irreparable harm. That usually depends on the level of the bond, the type of project, the type of contractor. Is there a prima facie case, in a sense, in terms of, do you have a case, for example, say it's termination against termination, and then finally, is it urgent? Of course, it is urgent because you know it could cause you irreparable harm. So tribunals often, you know, particularly experienced tribunals would take, for example, the view: look, this whole dispute is about termination. So for the moment, what we're going to do is we're going to park the bond to one side. You know, you say you extend the bond to the end of the arbitration. In the meantime, we will adjudicate this issue, and then at the end we will find out whether you're entitled to call the bond or. So essentially they freeze that issue, and that's often quite a sensible way of dealing with it, because if you've got a situation of irreparable harm, you could actually cause the contractor to go bust and therefore not be able to put forward the claims. So it's clearly fact specific. I'm not making any general statements on this, but tribunals often try and they take a slightly different view to the courts. They will certainly take a different view to the English courts, and no doubt Sally will tell us what the Dubai courts, how they deal with that. Sally, over to you.
Thank you, Raid. That's actually a very helpful summary and recap. And the situation in the UAE is not very much different than what you've mentioned. On-demand performance bonds is really very commonly used in this part of the world. It's usually a token that is used by employers to add pressure on the contractor, in many events also to exert pressure to avoid disputes, or to, as you just mentioned, to just put the contractor in a very difficult position financially to prevent that contractor from being able to bring or commence legal action against the employer. In terms of how UAE courts deal with on-demand performance bonds, the only way really to stop it is, as you mentioned, if the contractor can prove that liquidation of the performance bond has been made by way of fraudulent means, or if the court can find that the contractor really has a huge outstanding amount from the employer, or if there's really real evidence, for example, the contractor providing and taking over a certificate, or a certificate from the Dubai Lands Department, which is the authority here in the UAE that certifies completion of projects, confirming that the project is completed and really there's no reason for the employer to encash the bond. But from what we've seen in practice is that it is still very difficult to stop performance bonds from happening or from being liquidated. The moment the employer holds an on-demand bond, it just submits it to the bank. The bank then, in 2 or 3 days, liquidates that. The other corner, or the other angle of how to look at it, is that the only times that we've managed to stop performance bond liquidations is by way of ex parte applications by the contractor before the Dubai courts, where they would, before the employer just rushes and liquidates the bond, we would go very quickly to the Dubai courts, which now introduced much easier process of attaching or freezing attachment, freezing performance orders. This is the only way where we would, if we went before the employer. But if the employer decides to go and liquidate it, then I'm afraid there's really no way but for the contractor to commence arbitration proceedings in the hope of then being able to recover what the employer has liquidated at the end of the arbitration. But it is definitely an imminent risk that we're still seeing up until now.
Thanks, Raid and Sally. And so, Sally, a follow-up question, and this comes from Joe in the audience. Could the encashment of a bond for no reason be taken as bad faith under civil law jurisdictions?
That's actually, I mean, it's a very important question. And as you know, like here in the UAE and the GCC, really, good faith plays a very important role. We've seen recently in one case, the employer taking the strategic decision just to show the tribunal that they're acting in good faith by not liquidating the performance bond. So yes, there are strategic decisions, especially during an arbitration. Once an arbitration starts, as you know, like both parties would want to make sure that they're maintaining their credibility in front of the tribunal. So one way to do it is for the employer to say, you know what, I know I have a legitimate claim as a matter of good faith. I'm not going to go and liquidate the performance bond. I'm going to wait for the tribunal to issue an order confirming that I'm entitled to what I need. And I'm sure I'll be able to recover not only the monies under the performance bond, but way even more than the value of the performance bond itself. So yes, bad faith is definitely argued, and it is considered once an arbitration is started and a tribunal is in place. Before that, I'm afraid not. Employers actually go and liquidate performance bonds very quickly to add leverage and to give them leverage by way of settlement, to add pressure on the contractor to come to the table and try to settle before bringing a dispute. So it is, unfortunately, yes, a very difficult threat and risk that keeps contractors really on their feet.
Thanks so much. So a related issue to the topic of bonds is where, in the face of mounting problems on a project, parties may ultimately think about or be threatened with the nuclear option, which is termination of the contract. And so let's explore the practicalities and consequences of termination that parties should consider, and also think about the potential pitfalls And commercial alternatives, apart from the legal remedies under the contract, alternative determination that should be kept in mind. Raid, could you lead us off here?
Yeah, I mean, I think it's funny how it's all ties up to the bond. So say this is an example for you. You got a project that there is no need for it in the same time frame. Say the owner doesn't need it in the same time for whatever reason. They've got a bond, a large bond. So what they do is they terminate, and then they call the bond. They take the money, they sit on it, and then at a later point they use the money towards completing the project. Maybe in a different way. They try and avoid the obligations. It's often what we see is termination is being done for the wrong reasons. Yeah, it's done for commercial reasons. It's not being done for really what is the fundamental entitlement to terminate. Contracts usually provide very strict reasons to enable you to terminate. The position is even compounded by how tribunals view this. Tribunals see essentially termination on a project where you're going to cause. What happens when you event of terminate? You physically kick out the contractor out of the site. You take often his property or have property equipment. You've called the bond. The implications, you take over the documents, etc. The implications are draconian. The tribunals often view it. It's got to be a final resort. It's a last resort. Okay, and under English law, for example, you've got, of course, you might have two strands. You might have a process which provides for material breach, where it's a contractual process for termination, and at the same time you can have a situation where you've got repudiation of the contract. But I think if you think about it, the test under English law is for the contract to have been repudiated. And that's a pretty high threshold. It's not because I actually, for the moment, actually, I don't need the contractor. I'll put him out for a bit. I'll think about it. And so what is absolutely important is that you set very careful mechanisms that would allow you to terminate and for what reasons. And I think, if you are serious about terminating, you've got to think, okay, if you think the mindset of the tribunal that this is a pretty serious act, you've started by saying it's nuclear. Yeah, so that's how some tribunals will look at it, at least. So on that basis, if you're going to actually go all the way to this termination, you've got to start thinking, well, 2 or 3 months before, I need to start writing some correspondence that it really set this up. I can't really out of the blue decide one day, get up and say, I'm going to bid you farewell. You've got to start writing letters saying, look, there's a failure here. You're not doing this. You're massively behind in terms of your performance. You're not meeting the schedule. You're endangering the whole project. All of this needs to be ventilated. You need to deal with any extensions of time applications. You need to demonstrate that essentially you were left with no option, if you are the employer or the main contractor, that you are faced with the situation that you have to terminate. So it's a very, very serious situation. It's a very, very serious step to take, and a huge amount of attention needs to be taken, not only to the contract, the applicable law, but the forensic evidential aspects that you would need to do. And tribunal will be thinking, well, when you terminated, what was your view? Did you think about this? Did you take all of these things into account? What was the level of performance? Where was the design? Where was the completion? What was the degree? What was the intention of the contractor? Had the contractor mobilized to meet those particular things that you were complaining? So it's not an easy task, and it needs a lot of cold towel type on your head thinking before you take such a step. I don't know, Sally, whether you want to add to that.
I cannot agree more, really, and thank you for sharing all of this valuable insight, Raid. I mean, in the UAE, all the majority of disputes we've seen all revolve around wrongful termination. So we see a lot of cases where contractors just rush to terminate their contract, demobilize from the site, and just disappear, leaving the employer with no option but basically to appoint other contractor for that contractor to complete their works on the project. Now, the difficulty that happens here is that as a matter of UAE law, and it is a principle upheld really across the board in the GCC, is that if a party disputes termination, so if an employer disputes termination, termination will not take effect until after a tribunal is appointed and legal action is commenced that would confirm that the contractor is entitled to termination. So up until that time, the contractor is expected to stay on site until the tribunal confirms its entitlement to termination for the very reasons, like once it justifies that it has valid grounds that would warrant a termination. We've seen cases where contractors that really do not appreciate that, and then they found themselves really faced by very huge damages and compensations by the employers, not only recovering the damages that they sustained as a result of the contractor demobilizing, but also claiming all other costs of the contractors and subcontractors that came into board as a result of the contractor's departure from site. The other angle of where we see also a big or huge issue with termination is on the employer's side. They also rush to terminate on the assumption or understanding that once they do that, they will be able to levy or to impose the liquidated damages clause under the contract. Again, not realizing that as a matter of law, once termination is confirmed by a court or a tribunal, what happens is that all the elements of the contract falls away, including the agreed penalties. So any liquidated damages just falls away, and the employer in that instance will only be entitled to claim damages on the basis of the general provisions of law, which states a much higher threshold for a party to be able to claim damages as a result of termination. So these are all tensions that we continue to see up until now. And unfortunately, it's just, the issues that keeping really developers and contractors really in dispute for a very long time.
Thanks very much. So Scott, let's turn back to you. And we'd love your comments on what we've been discussing about bonds and termination, but I'd also like to pose, another question to you. And, at the outset, you started us off by talking about these numbers of pressures and factors that come to bear on parties to construction contracts. And you mentioned the current geopolitical circumstances playing a role as well. Raid also mentioned that, in circumstances where a bond is called, that could make a contractor go bust and put them out of operations. And so, Scott, what are your thoughts as to whether all of these factors have already led or maybe will lead in the future to a wave of insolvencies in affecting contractors or affecting other parties in the supply chain? What steps should stakeholders in major projects take, both to protect themselves and the project from potential insolvency at any level in the supply chain? And then, I welcome others' thoughts on a jurisdictional comparison of insolvency laws in different countries and how they play a role in all of this. So Scott, back to you.
Yeah, I mean, I would say I don't think we've seen a wave yet, but that's not to say that it's not possible. I think the issues around COVID and the current other crises that are happening as a result of that, and obviously the geopolitical issues, they haven't necessarily had the same effects as the financial crisis had, for example, but that's not to say that there haven't been any, and there are some, and there've been one or two fairly large ones, and I'm sure there will be some more to come, because these effects are continuing and in some circumstances increasing in certain regions of the world. I mean, I think we here in Asia obviously, particularly in Hong Kong, we rely a lot on labor from mainland China. That hasn't been able to come across the border for the last 3 years. So, we've got major issues in that kind of supply. There are obviously, China is the manufacturer for the world. The vast majority of construction products bought in this region come from China. The supply chain issues, increasing prices, obviously trying to source from other areas with higher cost bases. So these pressures, I think, are continuing and growing, and leaving certainly some contractors very close to the edge on a lot of these issues. I think thankfully we haven't seen it to the extent that we have in previous financial crises, I said, but it is happening. Just kind of dropping back onto the issues around termination, kind of building on something that Raid said, it's one thing you see is almost that sometimes clients think it's a bit of a blank check, that once I terminate, it doesn't matter what it costs me, I'll the contractor's going to pay for whatever it costs me to complete the project, and that absolutely is not the case. And not only do those costs have to be reasonable and substantiated, it's actually very difficult to record and secure all of those costs that you incur, whether they're reasonable or not, as you go through, and whether that's through arbitration proceedings or litigation or whatever, the chances of you actually recouping all that cost are pretty much slim to none. There will always be a differential between what it's going to cost you to finish that project and what you actually recover. So it's another reason why you really should take a step back and think twice about what you're doing. And that commercial aspect is one which I think is not sufficiently considered when people enter into terminating projects.
Thanks so much. And I'll invite Sally and Raid to comment on this as well. But in the interest of time, I'll also like to pose some of the questions that we've gotten in the last few minutes from our attendees. And we'll try to get to as many of these as we can, although we may only have a couple of minutes left. So one question is whether you've seen any successful claims for extraordinary price adjustment following an increase in the price of raw materials. Another question, and any of the panelists, please feel free to pick up on either one of these, is a situation of termination where the employer asks the contractor to vacate the project within hours and takes over the contractor's plant, accommodations, etc. So are either of these scenarios things that you've seen in your own disputes practices, and how have those situations been resolved?
I'm happy to take the one on termination because it reconciles with a recent dispute that I've been involved in, where the employer has exact same intention of getting rid of the existing contractor, and just needs to find a way to try and get that contractor out amicably first. But that contractor is saying, no, we're just in the project, we're going to do our job, and you have no right to kick us out, basically. There were two options that the employer had in this case, and one of them that is something that they've done is that they've involved the police. Basically, they called the police saying, look, the contractor is just on site, they're not doing their job, I want them out. Then the police didn't do anything. They just said, you know what, you have a dispute, you need to go to the proper channels, you have a contract with that contractor, you have no option but to go and to commence arbitration and get a valid order from the tribunal confirming that that contractor is not doing their job. But until this happens, you have no right basically to kick them out. So it is an issue that we're seeing at the moment. There are instances where employers just don't care, and they do, just demobilize existing contractors and prevent them from entering the project, and they just deal with the consequences of that. So yes, I mean, it is a valid issue that we see really time and time again.
So just on price escalation, that was the other question, I think.
Right.
So, well, I mean, usually you provide for that expressly in the contract. If you don't, then if it's a lump sum contract, usually you bear the risk for that. But if you've contracted under, civil laws, you might be able to argue hardship, imbalance. That's usually an Egyptian law concept. It's not actually prevailing everywhere in the Middle East, but in Egypt, rebalancing. I think you got some other civil laws that have that. Brazil have got rebalancing. You might be able to, in Saudi law, you can argue that it's other. There's a principle of other, meaning excuse, and so you might try and argue some sort of rebalancing on that, or some element to redress the balance. But unless you provide, for example, that it's set that the certain material that you will be provide for an adjustment, I think the principle of contracting is that you raise the risk, and usually contractors should be, add a few contingency items to cover for those particular events, which are usually not unforeseeable, because prices going up and down, arguably is not foreseeable.
Yeah, just to add to that, things that we have seen is, and probably particularly related to kind of COVID effects and the impacts that that has had on supply chains, and therefore obviously pricing, is contractors looking for ways to tie back those impacts to provisions in the contract other than the force majeure. So the change in law type provisions, where perhaps the impact on the supply chain is a direct consequence of closures of borders or things like that. That there you can kind of draw parallels between a cause and effect. I'm not saying any of them have been particularly effective so far. I haven't seen outcomes, but there are other ways of approaching those problems within contracts.
Terrific. Well, thanks very much to all of you. Unfortunately, we've reached the end of our time today, but I think the attendees will join me in thanking all three of you for your insights. I think this was a very informative and interesting discussion, and hopefully one that we can all continue in future programs. So thanks again to Scott, Sally, Raid for leading us off and educating us on all these interesting topics. And thanks very much to the attendees for your participation, and have a great rest of the day. Thanks, everybody.
Many thanks, everyone. Thank you very much. Thank you.